Hello, everyone, and welcome. Today, we're going to break down a really important part of India's new Digital Personal Data Protection Act, or the DPDP Act. We're talking about your right to appeal. So let's dive into what you can do when you need to challenge a decision. Okay, so just imagine this for a second. You've gone to the Data Protection Board about an issue with your personal data. They've looked into it, and they've made a ruling, but you completely disagree with it. What do you do now? Is that the end of the road? Well, the good news is you're definitely not stuck. The DPDP Act actually gives you some really powerful options to take things further. So in this explainer, we're going to walk through exactly what those choices are so you know your rights inside and out. All right, so the first and most structured path you can go down is what's called the formal appeal process. This is your official chance to get the board's decision looked at again, but by a higher authority. And who is this higher authority? Well, it's called the appellate tribunal. Now, instead of creating a whole new body from scratch, the law gives this job to an existing one, the Telecom Disputes Settlement and Appellate Tribunal, or TDSAT for short. They're the next level up. Now, if you're thinking about going this route, there is one number you absolutely have to burn into your memory. 60. That's right. Under Section 29 of the Act, you get exactly 60 days from the moment you receive the board's order to get your appeal filed. And trust me, this is a very strict and really crucial deadline. So, what does this whole journey look like? Well, first you file your appeal. The process is designed to be fair, so both you and the other side get a full chance to be heard and present your case. After that, the tribunal has the power to either agree with the original decision, change it, or even just throw it out completely. The Act also pushes for speed, aiming to get the whole thing sorted out within 6 months. Okay, so the tribunal has heard everything and they've made their decision. But how much power does that final word actually carry? What does it really mean? A whole lot, actually. This quote from Section 30 of the Act is everything. It basically means the tribunal's order isn't just a suggestion, it has the exact same legal power as a judgment from a civil court. It's binding and it's enforceable. But hang on. What if a formal, kind of court-like process isn't really your style? Well, the DPDP Act gets that, and it actually provides some simpler, more collaborative ways to find a solution. So, what's the big difference here? A formal appeal is all about challenging a decision and having a higher authority make the final call. Alternate resolution, on the other hand, that's all about working together, being flexible, and trying to find some middle ground that everyone can agree on. The first of these alternate routes is mediation. As Section 31 lays it out, if the board looks at a case and thinks, hey, these guys can probably sort this out by talking, it can direct both sides to try it. A neutral third person, the mediator, steps in to help guide the conversation and help you reach an agreement that you both create together. The second option, which you'll find in Section 32, is something called a voluntary undertaking. This is basically a formal, binding promise made to the board. A company might promise to change a policy or take a specific action to fix the problem. If the board accepts this promise, all the legal proceedings stop right there. But, and this is a huge but, if they break that promise, it's considered a direct violation of the DPDP Act itself. Okay, we've covered a lot of ground. So let's just pull all of that together and make sure the key takeaways are totally clear. So let's do a quick recap of your 3 main options. First, you've got the formal appeal. Remember that 60-day window to challenge a decision at the TDS Act. Second, you have mediation, the collaborative way to find a solution that works for everyone. And third, the voluntary undertaking, that formal promise that can stop the whole process in its tracks. Knowing these 3 is absolutely key to navigating your rights effectively. And all of this brings us to the big final question. The Act has created these really clear pathways for people to seek justice, from a formal appeal to more cooperative solutions. The real question now is, will these new routes actually work in the real world to make data protection in India strong and accessible for every single one of us? I guess only time will tell. Thank you so much for watching. If you found this helpful, please give it a like and subscribe for more explainers like this. And just a quick note before we go, this video is for educational purposes only and isn't professional legal advice. Laws can change, so it's always a good idea to consult with a professional advisor before you take any action. This is an AI-generated video.